I'm not sure I'll know as well as our last speaker what is likely to happen inside, but my task was to give you a bit of a pregame show in terms of exactly what is going to be up and what to watch. And is that tomorrow at 10 there'll be 90 minutes on the Anti-Injunction Act, and I'll explain that in a minute. And then on Tuesday, coincident with the big rallies coming up, we'll have the individual mandate, or what's we call, I guess, what is it, minimum coverage is one of the technical terms, minimum coverage provision, which I'll mention, and that's 2 hours. And again, it's normally 1 hour for a case in the Supreme Court, is that right? So no matter how gigantically important, of course Dan is sitting right in front of my camera, that's ruined now. So anyway, but no matter how earth-shattering the case is, the Supreme Court says you get 1 hour. Here they're getting like 5.5 hours, which is extraordinary. So 2 hours on Tuesday, which then I think starting about 10, which I think about 1 o'clock will mean the audio, and of course that's mainly the big issue, but I'm going to explain that a little bit. And then on Wednesday, I think there's 1 hour on severability, and the other on Medicare expansion. So there's really an extraordinary constellation of 4 huge issues going on here. So you really are going to have a ringside seat on a bit of history here. We think, you never know how these things go out. So basically, I think you've heard, especially earlier tonight, about how sweeping and broad and what impact Obamacare has. But the constitutional issue, as was touched on already, is going to be an unrepresentative, warped view of all of that. The vast majority of Obamacare that people object to is, of course, not going to be the subject of the Supreme Court case. Although it isn't true that, if this case doesn't come out the way we hope, that doesn't mean there might not be later lawsuits about other issues that may come down the line, as was touched on, about the women's rights issues. But this is considered to be just kind of the silver bullet, and the main issue for that is just because the individual mandate is so far over the line that it was considered the Achilles heels, in addition to the extraordinary situation that the Congress didn't put in a severability clause, saying that might be because of the mad dash. You all remember, and someone asked me to point this out and remind everybody that the Tea Party movement largely was born in part about this, about the cries of "read the bill." There was a lot of issues. I think for everybody, the last straw was a different last straw from one person to the next. But this whole process and passing a bill, we don't know what it says, and we have to pass it to find out what's in it. And the cries of "read the bill" was one of the reasons the Tea Party people got off their couches watching TV and went out into the streets. And so in that mad rush, that might be only the accident of why we don't have a severability clause, because they were just too much in a rush to get all this nonsense done. Now, as you may remember, there was this gigantic bill passed, and shortly thereafter there was a huge amendment. So there were really 2 bills, and they only got the votes to pass the first one based on the promises that, oh, we'll pass this and we'll fix it. So there were really, on some of these things like the individual mandate, there's actually 2 bills that have slightly different renditions of this, but they all together create this monster. Now, unfortunately, so whether or not this entire thing rises or falls is going to depend not on the policy wisdom or all of the reasons we have about it, but a couple of accidents. And the individual mandate, of course, one of the problems is that my brother works, although it's shipping insurance, he deals a lot with insurance and the problem of adverse selection, where if you say that you're guaranteed insurance even if you have a pre-existing condition, the temptation then is to say, as I don't know if we covered this before, the temptation to say, well, then I'm not going to get insurance, I'll wait until I get sick. So the whole thing doesn't work, because like in my brother's example, he does shipping insurance, he worked for FedEx for 5 years. They say, well, I won't get the insurance until my package is already lost. So that the whole thing financially collapses. So that's why it is so much at the heart of the whole process. But the two things that are going to going to happen, and going to be the big issues, the big debates, is really going to be whether or not it's a tax. And Mr. Davis, I'm sure you can talk about how the twists and turns of what you think are going to happen and what you think the judges are going to focus on. You can be surprised, like what happened? You know, how did we get here? Because the first huge battle is going to be, is this a tax or not? Now, what the heck does that mean? Because what happens is, and I did a proposed amicus brief that we were thinking of trying to get organized in Virginia, and I did a lot of work on it, but we never got to the point of putting together the whole program to get a lot of Virginia legislatures on board. And so I analyzed it and realized that the Patient Protection and Affordable Care Act, again in two parts, requires that, in fact, let me read it. An applicable individual shall, for each month beginning after 2013, ensure that the individual and any dependent of the individual who is an applicable individual is covered under minimum essential coverage for such month. Now, the terminology, the gobbledygook, of course, refers you to somewhere else where the HHS has enormous power to determine what minimum essential coverage is, gives them a lot of broad discretion. Well, what I don't think I've seen anybody focus in on that struck me was that you will be required not simply to buy insurance, but to go through the mental process of ensuring that you and any of your dependents have the minimum essential coverage. So they're actually commanding you to think. They're not just commanding you to buy stuff, they're saying you have to go through a thought process, you know, per order of the government. So you have to think about your dependents, you have to think about yourself, and you have to think about the minimum essential coverage, and you have to make a mental calculation to ensure that you're meeting that. So it's really thought control to an extent, even more than just you know, interstate commerce thing. But what happens if you don't? If you don't, you have to pay a penalty, and it is clearly marked as a penalty. But the IRS is commissioned to police that, because everybody supposes to file a return, so you're supposed to check a box and say that yes, I did or I didn't. So while it's clearly marked as a penalty, and it's clearly based upon we command you to do something, there are a lot of, and it was, I think there's language, and the President Obama said at the time, it is not a tax. There's a lot of people saying the legislative history, which often people look at, meaning the debates in Congress and everything like that, it's clearly no support for the idea that it's a tax. They're trying to say, oh, it's a tax. The reason being that the Congress has broad authority to tax any way it wants, if it really is a tax. So they're trying to squirm out of the problem with the Interstate Commerce Clause by saying, oh, we're not commanding you to do something, we're just going to tax you if you don't. And so how that's viewed is going to be one of the biggest issues, I think potentially the biggest debate. And the first day is this oddball thing I never heard of before, the Anti-Injunction Act, which is designed, which is based upon assuming it's a tax, which is a gigantic, in fact, I don't even know why they're taking that up first, because the first assumption is, assuming it is a tax, there is a statute that says that the courts cannot interfere in the assessment or collection of a tax by use of an injunction or certain things. So what they're trying to say was, well, let's just assume it is a tax, which is a big question to begin with, and then this case can't be heard. The issue is that the courts can determine your tax liability after the fact, but they can't restrain taxation in advance. So the argument is going to be this whole case has to stop until maybe 2013 or 2014. Now it's interesting because, as near as I can tell, nobody who's a party to the case actually believes this. But a couple judges in the appellate court apparently raised this idea. It is true that a court is always supposed to question its own jurisdiction, whether or not it should be acting. And so the couple, they raised this issue by themselves. And both, there's briefs even by the government, by the Obama administration, basically discussing it back and forth, but really saying we don't believe that this case is blocked by the Anti-Injunction Act.